Detectives have completed their investigation into the fatal car accident involving Caitlyn Jenner earlier this year. They will present their evidence to prosecutors next week and determine whether or not Jenner will face misdemeanor manslaughter charges. Now, the accident happened in Malibu back in February. Police say Jenner was driving too fast, hit another car, and caused a chain reaction crash. I want to bring in HLN legal analyst Joey Jackson to talk a little bit about this. Joey, good morning to you.
Good morning, Lynn.
You know, we do know from the investigation, according to police, that while he was driving at an unsafe speed, it was under the speed limit. So let's clarify what exactly warrants a manslaughter charge.
Absolutely, Lynn. So what will happen is that the police are going to look at two things. Number one, they'll look at Caitlyn Jenner's conduct. And number two, they'll look at the surrounding circumstances. Manslaughter. Did you act in a way that was negligent? And so they would have to determine, what was he doing? Was there any distraction? Did he fail to perceive the risk? Was he acting in a careless way? Was he acting in a way that a non-normal, unreasonable driver would act? And so under these circumstances, they'll look and they'll say, on the Pacific Coast Highway, he's driving northbound. There's a Prius that's gray and it stops in the road. And lo and behold, a Lexus ends up hitting that car. He's behind the Lexus. He hits the Lexus. It gets pushed into oncoming traffic. So they'll have to determine, was it a simple accident, as unfortunately happens every day, or was there criminality? And in determining that, they'll look at those surrounding circumstances that I just mentioned. And if it shows he was distracted and he was acting unreasonably, there would be manslaughter. If it shows it was an accident, as happens, then there would be no criminal charges filed at all.
I guess your professional opinion, as a criminal defense attorney, you're talking about a charge that could bring 5 to 12 years in prison. You think this is likely?
Not at all. And so what they're looking at, Lynn, at this point is the misdemeanor one. And the misdemeanor one would carry up to a year. That's the misdemeanor charge in prison. But I don't see under this circumstance that a charge would lie. Now, there may be something else in that report. I might, remind you, of course, that he took a field sobriety test at the time. He offered to give blood. He's been cooperative. There's no indication of any, type of anything in his system. So as a result of that, I just don't see the criminality. Now, negligence and lawsuits, of course, there are two. That's a whole different standard, whole different ball of wax. I do suspect that there will be money damages that would be paid, but criminal charges I do not suspect, in my opinion, Lynn.
Always helpful. Joey Jackson, thanks for being with us. You have a good rest of your weekend.
Thank you, and you, always.